Welcome to Gateway Pacific Law Group, where we empower employees and fight for their rights. Today, we're here to shed light on a critical issue: misclassified employees under California law. The information presented in this video is for educational and advertisement purposes only and should not be considered legal advice. Go to our Linktree address after you view this video to check out our website and social media accounts. There, you can level up your knowledge on California's misclassification laws. Learn even more about who is considered an independent contractor and the difference between exempt and non-exempt employees. Plus, you can find other employment law-related topics and even helpful documents to download. Also, don't forget to hit that subscribe button and ring the notification bell so you won't miss any of our future videos tackling important legal topics. Finally, stay tuned so we can tell you how you can have a chance to win a $50 Visa gift card. Now let's talk about California's employee misclassification laws. What is employee misclassification? It's when an individual is treated as an independent contractor or an exempt employee, but they should be classified as a non-exempt employee according to California law. It is important to know if an employee is being misclassified as an exempt employee or as an independent contractor, because a misclassified employee is denied the rights and benefits they deserve. For example, California law requires employers pay their non-exempt employees overtime. Also, non-exempt employees have specific limits on the number of hours they work in a work week. Additionally, employers must provide non-exempt employees meal and rest breaks. Employers generally don't have to do this for exempt employees or independent contractors. So, who is generally considered an exempt employee? Exempt employees are typically classified as professionals, executives, administrators, or outside salespeople. To be considered exempt, employees generally must meet three main criteria. First, exempt employees must receive a fixed salary that meets or exceeds the minimum salary threshold set by California law. In 2023, employers must pay their exempt employees an annual salary of at least $64,480. However, this amount changes when the state's minimum wage is revised. Nevertheless, an employee may still be misclassified because there are two additional requirements that must also be met. The next requirement is the duties test. Exempt employees must primarily perform duties that generally involve higher-level responsibilities and decision-making authority. Some of these job duty descriptions are in California wage orders. There are some exceptions, so see a lawyer who specializes in evaluating misclassified employee cases, like Gateway Pacific Law Group. Finally, exempt employees must exercise independent judgment and discretion in their work, such as making important business decisions or supervising other employees. Okay, so what's a non-exempt employee? Non-exempt employees must be paid at least the state's minimum wage for all hours worked. In 2023, non-exempt employees must receive a minimum wage of $15.50 per hour, although some non-exempt employees can be salaried. Non-exempt employees are entitled to overtime pay at a rate of 1.5 times their regular hourly rate if they work more than an 8-hour work shift. There are even more overtime rates of pay that apply, so seek legal advice if you are working more than 12-hour days or 40-hour weeks. Additionally, non-exempt employees have the right to receive meal and rest breaks as mandated by wage orders. A lot of employers try to classify their employees as independent contractors, so they can avoid providing certain benefits that non-exempt employees are supposed to receive under California law. So, what is an independent contractor? Generally, but not always, an independent contractor is their own boss with their own business. They make their own hours, decide who they want to work for, and decide how much they'll charge for what they do. In California, the general definition of an independent contractor is determined using the ABC test, established in a 2018 California Supreme Court case called Dynamex Operations West, Inc. versus Superior Court. Generally speaking, an independent contractor must meet all three of the following criteria. Otherwise, the worker is considered an employee. First, the worker is free from the control and direction of the person hiring the worker. The worker can decide how to best perform the job that the worker was hired to do. Second, the worker performs work that is outside the usual course of the hiring entity's business. And finally, the worker is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as the work performed for the hiring entity, or in general, the worker does his job for other entities. Also, in California, if you are in the construction industry and you are misclassified, there are enhanced protections for you. See an attorney like Gateway Pacific Law Group to find out more information. Before we discuss how a misclassified employee fights for their rights, we want you to know that if you find value in this video and you want a chance to win a $50 Visa gift card, please give this video a thumbs up and comment on what legal subjects you want to see in the future. Please share this video with your friends and family, or even better, on your social media pages, because you never know who this information might help. Finally, subscribe to our YouTube, X, Instagram, Facebook, and TikTok channels. We post helpful and interesting legal content. We create different content on each of our platforms, so subscribe to them all. Now, on to the rest of the video. Employers who misclassify workers can face significant monetary consequences that they must pay to the misclassified employee, including civil penalties of up to $25,000 per misclassified worker, back wages and overtime pay for misclassified workers, repayment of unemployment insurance premiums, repayment of workers' compensation premiums, repayment of state and federal payroll taxes, and the employer may face a lot of other monetary penalties they may have to pay the misclassified employee. Misclassified workers who believe they are entitled to employee status can file a complaint with the Labor Commissioner's Office within the California Department of Industrial Relations, DIR. The DIR could investigate the complaint and determine whether the worker was misclassified. If the DIR finds that the worker was misclassified, the employer will be required to pay the worker all back wages, overtime pay, and other benefits that they are owed. Alternatively, employees who feel they may have been misclassified can also contact a law firm that has extensive experience in the misclassification of employees, like Gateway Pacific Law Group. Misclassified workers may also be able to file a lawsuit against their employer where they may be able to recover penalties, back wages, overtime pay, and other monetary penalties and damages. Now, you might be wondering, will my employer retaliate if I fight for my rights? Will I lose my job? What will I do financially to support my family? We understand this concern. But it's essential to know that the law protects employees who assert their rights from retaliation. Employers are prohibited from taking adverse actions like firing their employees or reducing their work hours against their employees who assert their rights. You are protected. Employers who retaliate against their employees expose themselves to even more financial punishment. The legal costs the employer will have to pay its attorneys to defend against a retaliation claim are substantial, and there are additional damages the employer would have to pay the employee. Most employers understand the law and the financial repercussions, and yet some choose to ignore the law. Those employers could face significant financial liability to the employee they retaliated against. Remember, If you suspect you've been misclassified as an independent contractor or exempt employee when you should be a non-exempt employee, don't hesitate to consult with an attorney. The employer is stealing your time and your labor. NBSP. At Gateway Pacific Law Group, we stand with you, ready to fight for your rights. Our experienced team will guide you through the legal process, ensuring you receive the justice and compensation you deserve. Contact us today.